Шановні колеги, ми продовжуємо співбесіди і просимо...
Dear colleagues, we continue our interviews and we invite our next candidate, Ірина Мостова.
Доброго дня, пані Ірино.
Good afternoon, Irina. We are happy to see you here today. So you can see that we have all 6 members of the commission, 3 online, 3 on-site. Today we will ask you the questions, and Matthew Murray will ask you those questions. He's our head interviewer for today, so Matthew, over to you. Yes, for interpretation, please use the headset.
Tatiana, thank you, and good afternoon, Irina. Let me suggest a couple of points about the procedure for this interview. First, we, would encourage you to use the headphones so that you make sure that you understand every question in detail, and the translation is there to help you. So if you have a question or you don't understand what's being translated, stop us and ask us, please. Secondly, you'll notice that when you're speaking, the headphones will be in your ear talking to you at the same time, so that when you're speaking, you might want to take the headphones off. It's more comfortable to take them off when you're speaking so that you're not hearing your own voice echo. And then finally, please keep your answers as brief as possible, under, from 3 to 5 minutes, let's say. We have a number of questions that we wish to go through with you today for the benefit of this process. So, Irina, let me start with the fact that you were once an official at the National Agency for Corruption Prevention. You served there from 2016 to 2020, and you were initially the deputy head, and then you became the head of the Department of Monitoring Compliance with Conflict of Interest legislation and other anti-corruption restrictions of NACP, which we will now refer to as the Conflict of Interest Department. And so, as I'm sure you know, there was a public report that was performed by a number of NGOs regarding this period of the NACP's performance. It's known as the 2019 Shadow Report. And in this report, the authors made a finding around the manner in which certain officials were appointed to key positions at the NACP without following certain competition protocols. And so, in particular, I'm going to summarize this because it's important for the public to understand what the report says. And then, of course, we will give you the opportunity to discuss these findings insofar as they affect you. But let me just bear with me for a minute. The report mentions that on May 24, 2018, the head of the NACP, Mr. Mongul, announced a competition to fill vacant positions in almost all structural units of NACP, except for the department on the Declaration, Verification, and Lifestyle Monitoring, the so-called Financial Control Department. No competition was announced for that department. As the deputy head of the Conflict Department, you applied for the competition for the position of head of the Conflict Department. However, you were ranked second in the competition, and the first place was taken by your then subordinate and current partner in legal practice, Mr. Igor Stepanov, who was the head of one of the subunits in the Conflict Department. Immediately after the competition and the appointment of Mr. Stepanov to the position, he was reappointed as the head of the Financial Control Department without a competition by transfer, and you then assumed the position of head of the Conflict of Interest Department as the person who had ranked second. The report describes about 10 other cases that took place following a similar pattern as a result of the competition announced in May 2018. Individuals who were expected to lead departments, other departments of NACP, due to their previous experience, took second places in the competition. Winners in these cases were transferred to the Financial Control Department immediately after the competition and appointment, while those who possessed second places were further appointed as heads of their respective departments. So I understand that there are times when working in government when it's important to fill positions quickly, and leadership needs to work within the rules, but act decisively and quickly to do certain steps. But in this case, as the authors of the report note, it is difficult to imagine a situation where all the individuals who won the competitions for the leadership positions agreed to be transferred to other positions immediately after winning an appointment, unless somehow this was prearranged, somehow it was discussed behind closed doors. And again, it's not necessarily, I'm not trying to, go back into this and sort of re-review the whole process as to whether there were actual violations here. I'm more interested in hearing your explanation of what happened. And let me just start with a very simple question, which is, you are familiar with the 2019 Shadow Report, correct?
Дякую за запитання. Так, я знайома з ним.
Thank you so much for this question. Yes, I know about this report. I was present during its presentation.
Okay, so how would you then comment on the facts that I just described, which I don't think are in dispute themselves? It does seem that this pattern took place. So how would you comment on this pattern of activity? What was happening at this time that resulted in this massive movement of people to the Financial Control Department in a way that seems to have overlooked procedural requirements under the law?
Я не можу відповідати за дії.
Well, I cannot be responsible for the actions of the Competition Commission and for the position of the NACP back then, because I wasn't part of this commission back then. To me, it was absolutely logical, this decision to take part in the competition to become the head of the department, because I worked at the NACP since the first days of its creation, even before it actually started implementing its activities. I was head of the department since April 2016 until August 2016. So before the head of the department was selected, after the head of the department got a higher position, it was logical for me to apply for this position, because I thought that I have enough skills, knowledge, and experience to be the head of this department. I had a lot of support on behalf of the employees of this department. Igor Stepanov approached me and said he also wants to take part in the competition to get this position. I wished him luck, and I said that we cannot have any kind of competition between us. I do not mind, no matter how this competition ends, we will continue having normal professional activities, just what we had before. For me, the results of this competition were an unpleasant surprise, because I didn't expect such a result. in any case, I would continue working as deputy head of the department, even if Igor Stepanov became the head. What happened after? To tell the truth, I don't know exactly the procedure. I understand the situation looks looks a little bit strange, but back then all these changes in the positions were new to me. Nobody discussed it with me, and I didn't require any explanations from the management. So this happened. I took this position, right? Well, the situation doesn't look very ethical, and but in any case, I do not have any relation to this situation. I wasn't aware that this would be the way it would happen, and that Igor would join the financial department.
Okay, thank you very much for that. So yeah, no one would, of course, question why you applied for the position. You were certainly qualified to apply, and in the end, you did indeed become the head of the conflict of interest department. What I'm trying to probe for is whether, from where you sat, you detected that there was some problem with the way leadership of the NACP was seeking to fill all the positions in the financial department without competition. And so let me just ask you whether at the time, once you realized what the net result of all this was, and in fact, there were several people sitting in the financial department who had not gone through competition, did you have an impression of that? And did you raise any concerns about that with your colleagues?
Так, я зрозуміла, коли
Yes, after 4 or 5 days, when Igor Stepanov became the head of the Department of Financial Control, I realized that it was some kind of a scheme, I don't know how to say, a mechanism of filling in different positions, because back then probably the head of the NACP thought it was easier to hold one competition instead of 2. I don't really know. I didn't discuss it with the head of the NACP, because this was him who actually approved the results of this competition. I didn't talk to the competition commission, because back then I was happy with the final result, that I became the head of this department, and I was able to implement the ideas that I had. Of course, when this quick transfer of Igor happened, well, when Igor won, I didn't have any doubts, because as of now, I think that Igor is a highly skilled specialist. That is why, after all this time, we started having a very so we already had very productive relations during our work, because our department during evaluation declarations, we had a lot of work. And that is why after we ended working at an NACP, I offered him to cooperate together. So when he won, well, it wasn't pleasant to me, but it didn't I didn't have any doubts. And when he transferred to another department, yes, I started having doubts, but I didn't ask any question. It was just obvious.
Okay, well, I think the question on many minds of my colleagues might be, how do you view this overall scheme, to use your word? And what would you do as director of the NACP to assure that the hiring processes followed by the NACP followed the law in letter and spirit?
Я вважаю, що, мабуть, з точки зору
I think that from the point of view of the necessity to fill in the positions, to do that, back then the head of the NACP thought that this approach was efficient. I cannot evaluate their performance, but yes, you're right, this procedure doesn't look as such having a lot of integrity, but probably there was a motivation to fill in those positions as quick as possible. What I would do, I wrote it in my motivational letter. I think that all competitions shall be held even now when there is this pause. Right now, all of the people shall be selected based on a competition procedure, even though now the law doesn't provide for the necessity to select heads of those departments. Those positions are very, very important. That is why there shall be a competition, a transparent competition with involvement of the public council. So when I was part of the competition commission, that's exactly what we did. We involved representatives of the public council, and the procedure of selection of candidates is important, and also there shall be such high requirements as we have right now when taking part in these competitions. So more checks, more checking of the information, and of course I am fully for this.
Thank you, Irina. Let me now turn to Ian. You resigned from the National Agency for Corruption Prevention. I believe it was on December 31, 2019. Is that correct? When you resigned from your role at the NACP?
Так, 31
Yes.
грудня
Yeah, okay.
2019 року.
December
so can you-
31st, 2019.
Can you tell us why you decided to resign from the NACP?
Справді рішення звільнитися
The
я
decision to leave this position was made by me in August of 2019. At that moment, I understood that I could not implement the ideas that I had for the development of the department. Basically, we were stagnating. To develop this direction, we needed legislative changes, we needed internal documentation, we needed support from all of the members of the national agency, and we did not have it. And I just did not see how I could develop personally or my department could develop. At the same time, I think sometimes in September or October, I was the acting head of the secretariat of the national agency because they had moved. I was responsible. I had responsibility with my team, so I decided I would continue working until the new head is appointed and I would leave. Probably the most difficult period was when we had the temporary acting head of the NACP, and yeah, it would have been the most difficult period because the whole team was under pressure, a lot of it. We only had to collect information and reports. We could not work. I was responsible for my team, and I had to be responsible until the end. And the moment the new head of the agency was assigned, I realized that the person had his strategy. Probably he would have some ideas about the people who would fill the position, so I left. Once again, I stayed until that moment, until the end, because I thought I was accountable with my team. Matthew, Natalia has a clarification, if you allow.
Okay.
Could you please say, at the moment, your team, did it support you? You said in the interview that your team supported you, but did your team support you at that moment? Yeah, my department, my team supported me, and this is one of my biggest achievements with NACP. This is the team. Most of them still continue working with the agency. I didn't only have support from my department. When I was moved to be appointed as the honored lawyer, I was supported by everyone. Good. When the institution where you work is stagnating, do you always leave and then you come back when things get better? Thank you. No, this is not a trait of my character. I just understood that there was a lot of negative stuff that had accumulated, and I would simply not be able to continue working. I will be honest. When the new head was appointed, I was made to understand that I was not on the future team, and I decided I would not go against the flow, and it would not be effective. So you do come back when things get better. They are not better yet.
So may I resume?
Yeah.
Okay. And so, Irina, let's now turn to when you were serving at the NACP during that period that you were there, we noticed that you also were able to obtain a law license, a license to practice law. So is that true in 2019? While you were serving at the NACP, you also earned your law license?
Так, я отримала законне.
Yes, the law did not prohibit me
Of course
to
not, yeah.
receive the license. I took the exam and I did my apprenticeship at the time, which I had free from my first work.
Yes, I mean, I wasn't suggesting that the law would prohibit it, but it's a great accomplishment, and congratulations on doing that while you were also working full time. That's very hard to do. So could you tell us a little bit more about the apprenticeship that you served, which is indeed, as you pointed out, a requirement of obtaining a license to practice law in Ukraine? Where did you work? What kind of apprenticeship? Which organization?
Я проходила стажування
I
одного
did this apprenticeship with one of the lawyers from the Council of Lawyers of the Kyiv region. My responsibilities were to do the tasks that were trusted to me by the head of my practice, and then I went to court meetings. But mostly those were practical assignments or tasks related to the cases of that lawyer. She gave me those tasks, and I solved them together with her, wrote the procedural documents.
Was it challenging to do that apprenticeship while you were also working full time? How did you manage that?
Ні, це не було складно, тому що в
That was
принципі
not difficult because, well, the most difficult it was to get ready for the exam. The apprenticeship was not as difficult because I could do it at the time that I had free from my main work. During my holiday, I could go to the apprenticeship and do the tasks.
Could you tell us the name of the lawyer at the Council of Lawyers who supervised your apprenticeship?
Так, це пані Лісніченко був.
Yes, that was Ms. Lesnichenko. She was the head of the disciplinary committee of the lawyers of Kyiv region.
Very good. Laura, did you have a question?
Yes, I have a follow-up question. You said you also went to court, to hearings. Usually the court proceedings are taking place during working hours. So how could you combine working in an ACP full-time with going to court for the apprenticeship?
Я сказала, що це відбувалося під час моєї
That
відпустки.
was happening when I was on my holiday.
So,
Пригадати справи якісь, які вам
Could you
доводилось.
please tell us about the cases on which you went to the court hearings or that you were leading when you were a apprentice? No, I did not have responsibility for any case. Those were all under the civilian code, completely unrelated to what an ACP was doing.
thank you, Irina. So let's now turn to the period of your work after you left the NACP, resigned in 2019 or December 2019. And then our information is that you, starting in January 2020, you formed a law firm called Credence Partners with two other former NACP employees, Yulia Shevchenko and Igor Stepanov. So could you start with just confirming, is that the case that you started a law firm in January 2020 with those two individuals?
Так, це абсолютно вірно.
Yes, this is
Okay.
absolutely true.
And so, and when did you start? You formed the law firm in January 2020. When did you actually start working as, you know, a lawyer or partner with that law firm? When did the actual work start? It was a little bit unclear from your biography as to when you actually started working as a lawyer with Credence Partners.
Я почала працювати
I
фактично
started basically with the very first days when that was created. I was a founder and a lawyer until 8th and 9th of September of 2020, when I went to work to the seaports administrations. I was invited to join them to create a system of risk management with this enterprise. I had experience of doing that, of analyzing and developing risks, including anti-corruption risks. So for a year, I did not practice because, yes, it was the 8th of September 2020, the 21st of October 2021. I worked in Odessa with the administration of seaports. And when I returned from that position, I was actively involved in my work as a lawyer. There, I had to analyze risks of some public law entities, that those are protocols related to the conflicts of interests and violating the rules of financial control, and I still do that.
And so let's talk about the first 8 months of your business activity as a, you know, as a member and founder of Credence from January 2020 to, I guess, August 2020. What kind of work were you doing at that point? What was the nature of the work you were doing as a lawyer?
Ну, по-перше, дуже великий обсяг
First of
часу.
all, a lot of time was devoted to developing this legal firm, with promoting it, with advertising its activities. We paid a lot of attention to the possibility of submitting proposals to the national agency when new methodological recommendations on the conflict of interests were developed. We had our suggestions, some of them were taken. But then I was defending people according to protocols drafted by the national agency. And there were several cases that we led together with colleagues, complaints in administrative courts of the decision of the national agency. No, that was not 2020. It was after I returned from Odessa. So those were protocols and administrative offenses and corruption risks for
So this is
law.
Irina, this is important. I'm trying to understand whether you were defending cases on behalf of clients during the period January 2020 to August 2020, defending cases before the National Agency for Corruption Prevention.
Були, от зараз я пригадую, що були
I
протоколи
remember now that there were protocols that were filed by the Department of Strategic Investigations, and I defended clients on the conflicts of interests. There were protocols by the national agency, but these protocols were created after I had left.
і протоколи, і зовнішня оцінка корупційних
Yes.
ризиків.
I did these protocols on the external assessment of corruption risks.
Okay, I mean, I must be missing something. You're saying, I'm just, again, the period from January to August, when you say you were working with protocols, does that terminology mean that you were defending cases on behalf of clients in front of the national agency?
Здається, зрозуміло, про що ви говорите.
I
Це
think now I understand what you mean. This is the limitation that lasts for 1 year for the activity to represent clients in cases where the other party is an ACP.
Right.
The question is this. Article 26 of the law says that we cannot represent in cases where the other party is an ACP. I did not have cases like that in my practice. Under the Code of Administrative Violations, it's defense, it's not representation. And our law on legal activities, on what lawyers do, these are separated. These two things are separated, and there was no prohibition to do defense.
Okay, so your interpretation of Article 26 of the law of Ukraine is that you can defend clients from cases brought by the NACP or generated by the NACP, and that is not somehow a violation of what the chilling period, the 1-year chilling period. Is that what you're saying?
По-перше, в Кодексі про
The
адмінправопорушення
Code on Administrative Violations doesn't say that there is a party which equals some person or entity which creates a protocol. The protocol is presented by the prosecution, and the law on the activity of lawyers does not prohibit that because it talks about 2 different types of activities. It's not my interpretation. It's that we thought carefully where we can, which kind of cases we take, where we can represent our clients and where we cannot. Where the third party was an ACP, neither me nor my colleagues, I'm absolutely sure of that, we did not take them. We only took the cases on administrative violations where we had to defend our clients and when an ACP was not a party.
Okay, and so you're currently, oh, sorry.
something. Що по вашому представництву?
In your opinion, how do you see representation? What were the cases where you could not act against an ACP in your interpretation?
Відповідачем було
Those
національне
are the cases where an ACP brought the cases or were responsible according to administrative proceedings.
тобто на ваш
This is where the clients are represented by representative. You mean to say that the criminal code and the code on administrative violations, where it was speaking about defense, you could do it, where we had the civil code, you could not. Well, whether it was specifically described like that or it's just a chance, but it really talk about representation. We studied that question from 2017, where we did receive complaints on violation of this chilling period from people who worked with the customs or in other places, and then moved on to being independent lawyers. We studied this question in detail, we talked to experts, and we all decided that it's representation and not defense. The Constitution of Ukraine only speaks about the right to defense in court, which is a form of representation of being represented by a lawyer. I used the understanding that an ACP had at the time and the interpretation that we had together with the experts and with the Office of the Prosecutor. Can I come with a bit more of addition? We have Article 26. It speaks about representing interests. The processes or the cases that you quoted, there's the cases on administrative violations. You only represented interests, or is it about representation of their rights, general representation? The question here is that we did not do representation, neither in civil or administrative proceedings. We didn't take part if an ACP was involved at all, as a defendant or a suer. So you're going to say that in criminal proceedings, or the biggest cases on administrative violations, the agency was not a party to these cases. The agency was not a party in our cases on administrative violations. Their participation is not foreseen by the code on administrative violations. You did not have the status of an entity which files protocols. Did you have the status of a party that could sue? The code on administrative violations does not specify parties that did the protocol. There are participants. It's either a person who is held accountable, a prosecutor, and a defendant. So you just follow the letter. If there is no such an term as a party in such a certain procedure, then you could do that. Yes, that was my logic. And really this question was raised during the defense in one of the cases, and no violations were found. If you have materials of that case where that question is discussed, whether it is proper that you took part, the Commission would be happy to see them. I know exactly which case that is. I'm not sure that there is a separate decision from the prosecutor about me as a defendant, but I'm not sure about that, but I know which case it was, and that question was raised with the prosecutor. I'm sure we have it, and I can give you that number.
Thank you very much, Irina.
Дякую вам.
Let's now turn to your current situation. You're currently working with Credence Partners. Is that correct?
Yes.
And are you an owner of the law firm? I mean, how do you, with your partners, how do you decide the question of ownership?
Я є одним із 3
I'm
співзасновників.
one of the 3 co-founders of this law company. There is 3 of us as of today. We have the decision of the founders on the distribution of dividends. Each of us obtain income, the dividends relative to the net income that we bring to the law firm. If I work, I receive dividends. If I don't work, I just don't receive.
Thank you. So now my understanding is that your current cases include many individuals, including government officials, judges, members of parliament, for example, who are dealing in one way or another with administrative charges and administrative cases regarding alleged conflicts of interest by these individuals. So am I correct that that is sort of the nature of your current practice, that you have many such clients?
Так, у мене є клієнти.
Yes, I have clients where we work on the conflict of interests, the violations of the rules of financial control, and also cases about assets defined as ungrounded
Right.
according to the procedural code.
Right. And that many of these cases, in one way or another, involve the National Agency for Corruption Prevention. In other words, they.
Не зрозуміло запитання.
I did not quite understand.
So in other words,
the question.
in your current client list, you have several individuals who have issues with the National Agency for Corruption Prevention, and you are defending their interests currently. I'm talking about the current state.
Так.
Okay.
Yes, yes.
Okay. And so we noticed in your advertising materials, and I'm not sure, maybe this is on your website, that you advertise defending individuals against persecution in cases of inaccurate declarations. We were curious about your use of the word persecution. In other words, it almost made it seem like, to my ears, that you were suggesting that when the NACP does its work, it is somehow politically attacking an individual. Persecution is a funny word. Could you explain your use of that term in your advertising materials?
Ну, це не зовсім так, там не йшлось мова про
Well, I wasn't really talking some kind of political persecutions about possible violations from the NACP or pressure from the NACP. And unfortunately, as a practice that we have right now, I can talk about these, as there are quite a lot of violations on behalf of the NACP, and every person, no matter whether they did a violation or if there is the process of investigation, each and every person has the right to defense and legal aid.
Of course. Yeah.
And in any case, I wasn't talking about political pressure, but from possible violations on behalf of the NSCP or any other state institutions.
Very clear. So is it your, but this is a good moment to pause, because I think the question on everybody's mind is, what will you do with this law practice should you be chosen as director of the NACP? How will you, what steps will you take with this law practice to assure that you can do the job as director?
Я вважаю, що
Well, I think that my practice as a lawyer will actually help me at this position because I saw the process of the NACP activities from the inside. I saw probably some kind of inconveniences or disadvantages in the legislation. I saw the practices of the NACP, especially within the past few months. Those violations that are happening, I saw them. And thanks to my practice, I know how to end those violations. Because no matter at which side I am sure that this process shall develop according to the law. Because for me, after the NACP, was more difficult to continue working as a lawyer, and the way back would be easier. Because when I worked as a lawyer, I still have a lot of work and a lot of ideas on how to improve the activities of the NACP. We provided our suggestions to the Commission during the external audit. I don't know whether they received it or not, but so the thing is, because I was working at since the beginning of the NACP, that is why I really care for the destiny of this institution, no matter on which side I am, if I work at the NACP or as a lawyer. Those cases that I have right now won't prevent me from doing my activities at the head of the NACP, because I can end the contracts with my clients to avoid any conflict of interests in a legal way.
Yeah, that's what I have no doubt that your experience is helping you develop what you might call a 360 view of how the NACP operates, and that would be helpful in the position of director. My question is about what you will do to end your law practice once you become director. What steps will you take under the law and regulations that apply to these situations to end your representation of clients, to divest yourself of your interest in your law firm, etc.?
Насамперед я зупиню дію адвокатського.
Well, first, I will end my permission to act as a lawyer. I will put it on hold, and then I would transfer my corporate rights to my colleagues. But most probably, I will leave this lawyer's firm, because even now I'm thinking about creating my own lawyers firm or some kind of a lawyers association. That's the situation that I'm looking at right now. So first step is to end my activities as a lawyer, or to resign from this lawyers association and to end my corporate rights. And of course, I will end all my contracts with the clients. These clients, all the clients that we are working actively with right now, they know about me running for the position of the head of the NACP, and they are aware that if I win, I will have to end providing them my services.
And how about in those situations where these same clients that you currently represent, their cases continue with the NACP? What would you do to recuse yourself from any involvement in those decisions?
У разі, якщо це дійсно буде триваючі справи,
Or if these cases will continue, I will have to inform about the conflict of interests with those people. So a decision shall be made about removing me from any participation in those investigations, or to regulate any issues in a legal way. The only dilemma is that the list of clients is a lawyer's secret, but I think that we'll be able to get on well with the clients, and I will be able to explain everything to them, and I will get their permission to disclose their names and to inform about the conflict of interests.
Thank you, Irina. I'm now going to turn to a series of questions about your own property declarations, and because we've used a lot of time this morning, I'm going to ask you to be very brief in your responses. You've been very brief so far, so that is very much appreciated. The first question is about your declaration for the year 2018, where you indicate that you received a gift of 500,000 hryvnia from your mother, and in 2020 you stated you received cash gifts of totaling 305,000 hryvnia from your father and another 465,000 hryvnia from your mother. Could you just explain for us I know you've explained this already in your written documents, but we'd like to do this in public. Could you please explain the sources of the funds of those gifts from your parents in those 2 years?
Так, скажімо так,
Yes. As for the amount of 465,000, this was our shared investment into real estate. The first amount of money my mom gave me to buy a car, because back then I didn't have enough money to buy the car. Back then, my mother, starting from 2010, she's retired, but she continues working, and she's also a private entrepreneur. My father is retired since 2000, the year 2000. My father is maximum amount of retirement. My mother receives quite a high salary, and she has always received quite a high salary. So receives her pension, and she also receives her income as a private entrepreneur. Yesterday, I calculated that, for example, the income of my mother, excluding taxes or expenses on daily life, expenses on daily life in general, since 2003, this is what I managed to calculate. This is $211,000. So starting from 2003. As of now, my mother is 68 years old, and during all her working life, she has been working long before this register of the tax service appeared. But taking into account the amount of the pension of my mother, you can see that she has always had a high official income. I'm the single child of the family, and I'm really grateful to my parents, not only for financial support, but for everything they have been doing. I wouldn't be able to be here today without their support. So what are their activities? Because, for example, I can see that there is this area of law, but I also can see retail, repair of cars and vehicles. No, it's not about my parents. I don't know where it is. Same address. I don't know. It is written here. Veselkova Street. The microphone is off. You mean my registration? My mother's registration? Well, I might be mistaken, but she provides services such as consultancy. She's an accountant, and I don't know why there's information about retail, about this sale of cars. She provides consultations on tax issues, on tax inspections. So this is exactly what she has been doing during all her working life, and there wasn't retail. And moreover, she doesn't work with cash. All the money she received officially on her bank account. No, not a single person in my family has been into retail.
Thank you, Irina. Thank you. So let me turn to another question arising with respect to your declarations. And I'm going to try to keep this simple because you've already, again, you've given us a written explanation, and we want you to review that written explanation as a matter of public interest. And this goes to the your declaration at the end of 2019, and forgive me if the math is not exactly right here, but I think it looks pretty clear that at the end of 2019, you reported that you had savings of approximately 1.4 million hryvnia. That included both hryvnia savings, US dollar savings, and euro savings. And so the total of that was somewhere in the range of 1.4 million hryvnia. And then as reported in 2020, you had a salary, you paid taxes, you had certain living expenses, and then at the end of 2020, nevertheless, the math, I mean, it shows that you had higher savings of 2.2 million hryvnia, right? And so your declared savings from 2019 to 2020 increased by approximately 741,000 hryvnia. And you explained this in your written explanations that you had deposited funds in bank accounts, and they somehow, this is where I'm not clear, so please forgive me, but according to this analysis, the money in the bank accounts may have been used to purchase bonds or to, in a way that earned interest. And therefore, that would explain why your savings grew, even though that would be the main explanation. So if you could, and again, I'm sorry if that question was not very well stated, but I'm sure you understand what I'm talking about. Could you please explain it for my fellow commissioners?
Дякую за питання. Вони в жодному разі не зросли.
Thanks for the question. Well, my savings didn't actually increase. It was just how I declared it according to the declaration. For example, in 2019, I declared $25,000 and 20,000 hryvnias. In 2020, by the end of the year, it was equal to 900 and 500 and 4,000 euros, but it means that I received on my banking account, you can see this amount of money, 1.5 million hryvnias. So I provided data of this banking account. I opened it to transfer money to this account. So this was the scheme to receive real estate when I had to buy obligations and because I didn't have enough money to buy the entire lot at once, I had to accumulate money on this account. Then I exchanged them into obligations, and then I exchanged it to the real estate, to the property. So probably you have the question about this money and you think that this is an increase of my assets, but actually they consist of those 16,000 euro and $20,000 that I spent and put on this account, and this 1,800,000 hryvnias. So this is the money that I have already invested. I couldn't use this money. I use this money only on this banking account to buy obligations, and this increase in savings was due to converting the dollars and euro into hryvnias. Matthew, I just wanted to clarify because we tried to calculate and we cannot really calculate it properly. Okay. In your declaration, you declared that you spent 1.7 million hryvnias. And on top of that, on your banking account, you declared savings 1,897,000 hryvnias. Do we understand that this is the same actually money you just declared as expenses and as an increase? Yes, you are absolutely right. I just didn't find any other way to declare it because these obligations that I had to buy, I had to put them on my account, which was open on my name, but actually the owner of this account was the bank. So I just put this money on this account, 1,897,000, and then from my salary, I continued investing more money on this account until the moment when I finally accumulated the amount of money necessary to buy the apartment. Okay, but when you mention your shares and liabilities and you do not mention this amount of money, because back then I didn't have them, I had to buy almost 8,000 shares, securities, and I provided all the documents about this. When I put the full amount on this account, I reached out to the bank, and the bank used it to exchange it the apartment. So the question is, why did you show it in the expenses if you just transferred them to the banking account, but it was the same amount of money? Well, yes, maybe there was some kind of an overlap, but back then I had to declare this. And I paid for these obligations. That is why I mentioned them. So you agree that this 1,708,100, this is the exact amount of money, right?
So do I get it right that we're talking about buying on installment, and you will have the right to property after you have paid all of the money, but that was processed with these bonds? Yes, that was what the developer said, how I had to proceed. So the developer then would buy those bonds of yours in exchange of your property right. Yeah, but I bought the bonds not at the face value, and then they would give me the property, and the cost of the property would be not what I paid when I got the bonds, but what the developer showed, which is probably twice as much. Okay, that's clear to me.
Thank you, Irina. Thank you very much. We have one more question for you. Thank you, Irina. We have one more question for you. And this is with respect to a car that you sold in 2018. After your appointment to the NACP, the public record shows that you sold your 2013 Mitsubishi car to Mykola Pisarenko, who was the father of the then head of the NACP apparatus, Alexander Pisarenko, and the car was sold for 208,000 hryvnia. And according to sort of public listings at the time, similar used Mitsubishis were being sold at a slightly higher rate of 300,000 to 450,000 hryvnia. So could you please clarify why the sales price was the sales price and whether you think it was below market value? and whether you see any conflict of interest here.
Дякую за запитання. Якби
Thank you for the question. I wish I knew that the car would be chasing me for so many years. I don't think I would have never bought it in the first place. What I want to say is really the car was sold for the price indicated by the experts. The information is not really correct. The car was sold in June of 2018, and I was appointed in August 2018, but I started selling the car in March of 2018. Maybe it was even end of February, I will not remember precisely. The prices that you're quoting as market prices were not to be found at the time, because from March to April, I had phone calls from intermediaries. I didn't get any or any proposals from people who really wanted to buy it. The maximum I was offered was 11,500. These were legal entities who bought used cars. I would, of course, wish I had sold it for the price that is quoted in the article. It would be good for me. I would have more money to get a replacement car. I had no profit in declaring such a low value, but the car was damaged, and my declaration for 2016 has expenses because of my road accident. But this money which I received from, not expenses, this is what I received from insurance, but it did not cover what I would need to spend on putting the car into order. There was no real interest when I started selling the car, because I was explained that there were lots of similar cars on the market that came to the market from the US. Then the right side of my car was really very badly scratched. And after that, I realized I would not really do any kind of serious repair to this car, and I thought I wouldn't be able even to sell it. And then I received a phone call of a potential buyer, and I informed the buyer about this additional damage, being a scratch from a garage door. So we met with that person. We went to the official dealership and asked how much it could cost to repair the damage. So I was told that changing this bumper and then doing some painting, all of that would cost $3,500. It was also including the cost for repairing the brakes. I informed the potential client. He said he would think, then he agreed. We went to Stolichny Highway, where we processed the documents. I saw how the person was called, the name. I don't know, is it a coincidence? And I asked, are you related? He said, yes, my son works for an ACP. At the moment, I didn't even think about the car which I sold and the participation in the selection. This selection procedure, you had to do anonymous testing, and the head of the secretariat had no influence on that. The commission was made of 8 people who took various positions within an ACP. So the head of the secretariat, I think, had no authority to influence the decision of the selection commission. And the decision of the selection commission had to be approved of by the head. The head had to issue the relevant decree. So I think, I'm joking, they would have to really share the money, which was the difference between the market value and the money that I sold, or I don't know, split the car somehow. So tired of this car. But that was already an inspection. We all had to provide clarifications. I submitted the documents, this expertise evaluation, and the contract of sale. There were no violations. I didn't really think that 6 years after I will need these documents. I just didn't keep them because I did not think I would ever need them again.
Irina, thank you very much. And so I understand your position now. It's much clearer. And I think that will, conclude our questioning of you at this stage. I think there's been a very extensive and elaborate interview, so we appreciate your willingness to submit to these questions and the time you've taken with us this afternoon. Do any of my colleagues have any further questions for Irina?
Запитань нема, але я думаю, що ми були б дуже вам вдячні, якби
We
ви
do not
надали.
have questions really, but I think we would be very grateful if you could provide us with the information on incomes of your mother, the things that were talked about during the interview, and then the documents that would be related to the car. I think I said it's been 6 months. I do not have the documents. Probably we can get that from the department that deals with such instances of protection of the economy. I think you can be free. Thank you very much and see you.